All right. Hi, everybody. We are live and welcome to this Facebook Live session where we're going to talk to you today about the Biden Comprehensive Immigration Bill that was proposed in Congress this week. We're also going to talk to you about ICE's new civil enforcement priorities memo that was released yesterday. And most importantly, we're going to take all of your questions and comments. So if you have any comments, just feel free to post them in the comment box here, and we will answer those questions as we're going through the presentation. So where do we want to start, Aaron? Where do you want to start?
I think we should start with the big bill that came out, and there's a lot to it. So you want to walk us through it, Jeff?
Sure. I'll just kick off a little bit about some of the different provisions of the bill. So the first one, and I think the one that's going to impact the most amount of people, is what we call lawful prospective immigrant status, or LPI status. And this is really the pathway to permanent residence for beneficiaries. So basically how this is going to work is that if you are in the country, you will be put on a path towards permanent residence for 6 years. So the LPI status will be a 6-year path to permanent residence. And it also applies to beneficiaries, spouses, and children. And if you qualify and you get on this path to permanent residence, after 5 years in LPI status, you can then apply to become a permanent resident. The requirements that we're going to talk about for all of these different pathways, whether it's DREAM Act or agricultural workers or LPI status, they all have the same inadmissibility grounds. And so we'll talk about those in a minute. But this first one that's going to benefit most people is this LPI status that will put people on a path towards permanent residence on a 6-year period, and then they can apply for a green card after 5. The other interesting thing about the bill and this LPI is that once you're granted LPI status, you'll be able to enlist in the armed forces into the military. And I think that's interesting because potentially then if you're enlisted in the military, you may be able to fast track for citizenship. That's one of the unanswered questions from this bill. Is normally if a person enrolls in the military, they can be fast-tracked to citizenship. What we don't know from this bill is whether that will apply to LPIs too. As far as physical presence in the country, you'll be able to travel outside the country without causing problems unless you have a trip outside the country for more than 180 days. That will be interruptive of lawful presence in the country. Other than that, you have to pass criminal background checks, national security checks, and show that you pay your taxes, but otherwise you'll be eligible for a pathway to permanent residence. Next provision is the DREAM Act. Do you want to talk about that, Aaron?
Yeah. So the DREAM Act is going to actually expand on some of the previous versions, including DACA as far as eligibility. So oh, and I forgot to mention that if you have questions and you put them in the comment box, we will try to get to them. Si tienen preguntas en español, también podemos responder a esas preguntas. But yeah, the DREAM Act, instead of having to had entered at less than 16 years old, which is the current requirements for DACA, it's going to go up to entering under 18 years old. People who have DACA will also have an expedited path to permanent residence and ultimately citizenship. So they won't have to do the same process as the lawful prospective immigrants that Jeff just described were. Some of the requirements will still be the same or similar. There'll still be background checks that need to be done. You have to have had your high school diploma or GED or equivalent. But otherwise, the fact that the age is going up is going to include a lot more people. The other thing is that spouses and kids of people who qualify through this DREAM Act can also be included in the process.
Yeah, the other thing I like about the new DREAM Act provisions is, in addition to qualifying based on a high school diploma or GED or the equivalent, you can also qualify if you have 2 years of college or a higher degree, or if you've served in the armed forces for 2 years, or, and this is significant, if you have earned income for at least 3 years, of which 75% of that earned income was on valid work authorization. So this is a wide expansion. Even if you don't have that education, you may still qualify for the DREAM Act based on work authorization. And you can ask for a waiver of the education, military, or work authorization requirement if you can make a demonstration of compelling circumstances. So obviously very broad protections and provisions for DACA recipients. One more point on this is that it makes DACA and DACA adjustment applicants eligible for ACA principals. So they would be eligible for the Affordable Care Act as principals, but not their dependents. So that's an important piece there. Let's see. Let's talk about the Promise Act. This is how we would protect TPS applicants. So as you know, there are hundreds of thousands of people in the country right now, many of them for decades, who've been in what we call temporary protected status based on conditions in their home country. And what this will allow is for those individuals who've been continuously present in the United States since January 1st, 2017, and who had TPS on that date to apply for permanent residence. And it will include spouses and children of TPS applicants, regardless of whether they independently qualified for TPS. The most important piece of the TPS Promise Act is that it codifies that if you are granted TPS, that is considered an inspection and an admission. And why is that important, Zach?
Sorry, I was looking at the comments. What was the question here?
One of the things this provision of law does is it codifies that a TPS, if you've had TPS, that's considered an inspection and an admission in TPS status.
A major issue that's been going on for TPS adjustment in general is that a lot of TPS holders come here initially without status. They either cross the border without any sort of admission, or they overstay a visa, something like that. One of the requirements to adjust your status is that you have a lawful admission prior to applying. So by including this provision, it expands eligibility, and it overrules some recent precedent from USCIS that's kind of bad for TPS holders adjusting in general.
And this issue is actually at the Supreme Court now, because the circuits have split on whether or not TPS is an admission in and of itself that would allow somebody for adjustment. So this would resolve that circuit split and resolve the case at the Supreme Court by codifying that it's in congressional's intent for somebody with TPS to be considered as admitted and inspected. Another provision of the law that's coming around is for agricultural workers. As we know, we've had huge problems with the H-2A and H-2B program in that it doesn't cover all agricultural industries. It doesn't provide more than a year of eligibility or status in the country to provide relief for domestic agricultural work. So there's a provision in the law that will allow agricultural workers who are either seasonal or temporary or permanent to apply for permanent residence if they can demonstrate that in the 5 years prior to application, they have at least 400 days or 2,300 work hours in the agricultural field. And their spouses and children will be included in their application for permanent residence. So you can see that there are already 3 or 4 different large-scale components that would allow people to apply for regularization in this country. It's the pathway to permanent residence, the LPI status, DREAM Act, the Promise Act for TPS workers, and the agricultural workers provisions of this bill. Now, regardless of how you immigrate, and realize that some people may have more than one method of immigrating. A person who has DACA may have the opportunity to immigrate based on DACA, based on the DREAM Act, or based on the LPI program. So you're going to have different avenues. But one thing that applies to all of them is the grounds of inadmissibility. So here's what everyone would have to show, is that they'd all have to show that they were physically present in the United States from January 1st, 2021 until the date that their application is approved. So continuous physical presence, but brief, casual, innocent departures will not cut off physical presence. In other words, as long as your travel is less than 180 days, that will not be interruptive of your physical presence in the country. Also significantly, in the past, if you're put into removal proceedings, that would cut off your physical presence. You would be considered to no longer have physical presence. This codifies that the issuance of a notice to appear does not interrupt your physical presence, and you'll still be able to qualify for these different provisions, even if you're placed into removal proceedings. Another provision that's interesting that I don't know how this will play out or whether it will even survive is that even if you've departed or been deported after January 20th, 2017, but you had previously been present in the United States for 3 years, the government will have discretion for family unity, humanitarian reasons, or if it's otherwise in the public interest to waive your physical present requirement on January 1st, 2021. So what this means, how I read this, is even people who've been deported post January 2017 may qualify to apply for this.
Jeff,
go ahead. Yeah.
Well, sorry to interrupt. This is the part where Zach and I get to drag you a little bit. Just because, you've been practicing for a couple more years than Zach and I have. And we're looking at this thing in the bill that's called V visas, V non-immigrant status.
Yeah.
So we haven't gotten to have fun with that so much yet. And I was wondering if you can explain what that is and in what form it's coming back.
Yeah, so this will be a benefit to people whether you're in or outside the country. As you know, in many family-based categories, there's a significant backlog. If you're the spouse or child of a permanent resident, it can take you 8-10 years to immigrate to this country. Well, way back when, probably before Zach was even practicing, there was something called a V visa that allowed you to enter the country or remain in the country and have work authorization while you were waiting out that backlog. And it was called a V visa. This bill brings back the V visa and allows people to apply for the visa if they're waiting in family-based backlogs. We're going to talk about what happens with the backlogs later, because to a great extent, the backlogs may be a thing of the past. Backlogs may actually go away by the provisions of this bill. But if you are in the backlog, you may have the eligibility to come into the country, be paroled in, or enter in V status and get work authorization while you're waiting out those backlogs.
My understanding is that these applications are going to be similar to applications for amnesty way back in the 1980s, and that there are privacy protections that mean that the immigration authorities aren't supposed to be able to use the information that you provide in this application to try to use to deport you. Is that right?
That's right. And that's really, really important because, when you're talking about millions and millions and millions of people coming out of the shadows, you want to encourage people to follow the rules and do what they're supposed to do. And so in order to do that, they're putting privacy protections into play so that if you apply for one of these benefits, the government would not be able to use that information against you in later removal proceedings. One of the big significant things that the bill does that I think is really interesting is the changes that it makes to asylum. There are some provisions of law that really make you ineligible for asylum if, for example, you don't apply within 1 year of your entry into the country. This repeals that 1 year bar. It would allow you to apply for asylum even if you didn't apply within 1 year. More importantly, it allows you to file a motion to reopen your case within 2 years of the passage of the bill if you were denied on that basis, if you were denied for failure to file within 1 year. So real big, significant provisions for asylum applicants. One of the other things it does, Aaron, is restore a wide waiver called 212C. I don't know if you saw that provision in the bill, but did you see it?
Yeah, the restoration of 212C is actually huge because back in 1997, with the last kind of major reform to immigration law and immigration courts and deportation proceedings, there used to be this provision called 212C. And basically it was a waiver of deportability or inadmissibility for people who had committed certain crimes and had become deportable. The thing that was important about it is that it was just really a weighing of equities or positive factors and negative factors. And if you convince the adjudicator that you really deserve to stay, then you win and you stay. That went away, and they replaced it with something, principally with something called cancellation of removal. But the cancellation of removal is harder to get, has a higher standard. For the non-lawful permanent resident cancellation of removal, you have to prove that your absence from the country would cause extremely and unusual hardship. For the 7-year cancellation of removal, for lawful permanent residents, lots of aggravated felonies mean that you're disqualified from applying. So this bringing back 212C means that a lot more people who get put into removal proceedings or into deportation proceedings would be able to have a defense to get out. Another huge change that would come if they were to pass this bill would be the change to the definition of conviction. So immigration law has a specific definition of conviction that does not really match up well with a lot of states' laws. And what the immigration law says is basically if you ever plead guilty to anything and there's any consequence to having pled guilty, whether it's, probation, paying some fees, doing whatever, then that's always a conviction. Even if the state lets you later expunge it or withdraw it because you've complied with a period of deferred judgment here in Colorado, for example, it's still a conviction. And this change in the definition of conviction would change that and mean that if there was an expungement or if they vacated the conviction, that the federal government and the immigration authorities would honor that by the state. And so it would allow a lot more people to get relief from immigration consequences through state laws, which vacate convictions. The other huge change that I actually don't know a lot about would be the judicial recommendations against deportation. And my understanding is that the criminal judge, who's not an immigration judge, would get to make a recommendation that the person should not be as a result of the criminal offense. Jeff, is that how it works?
That's essentially how it works. I mean, it's as I read the bill, it's in consultation with the Secretary of Homeland Security. So I don't think it's a done deal, but if a judge issues a JRAD, that it would be a foregone conclusion. But these used to be very popular back in the 80s, where judges, especially federal judges, would make judicial recommendations against deportation that would essentially stop a person's deportation. The other thing that it does, and while we're on the criminal piece of it, is it expands the exception for inadmissibility for what we call petty offenses, right? I mean, obviously, we don't want somebody never to be able to get a green card because they committed some minor infraction that's really not very serious. And in the law right now, if you have what's called a petty offense, which means that the maximum potential penalty is less than 1 year for this offense, and any jail time that was imposed is less than 6 months, you can ask for a petty offense exception. This expands that to allow for 2 petty offense exceptions. So you can actually have 2 separate petty offenses and still be eligible for all these benefits that we're talking about. Impacts on people in removal proceedings. We're going to have a lot of people in the backlog in court proceedings who may now qualify for one of these provisions. What the bill does is it says that you won't be removed. If you can show prima facie eligibility for one of these different provisions and you apply within a reasonable time, there will not be a final order issued on your case until that is resolved. So it actually could be that people in removal proceedings would have a defense against deportation for some of these. Okay. I'm trying to think if there's anything else. There's a couple of other minor provisions that we should talk about that are relevant to the population in general. One is that it reduces the wait time for citizenship from 5 years to 3 years. So you'd be eligible to apply for citizenship after 3 years. And then overall, it changes the backlogs. So first of all, on the employment side, it increases employment-based green cards from 140,000 annually to 170,000 annually. And it allows unused visas from 1992 to 2020 to be added to the ceiling. So any unused visas during that 20-30 year period could be added to that 170,000 number as a means of getting rid of backlogs. On the family side, all the FT2A beneficiaries, we're talking here about spouses of permanent residents and unmarried minor children of permanent residents, those will now be reclassified as immediate relatives. And that's significant because immediate relatives do not have a quota. There's no numerical limitation on the amount of immediate relatives that can come in every year. So everyone who's in that F2A backlog will automatically be converted to immediate relative, be automatically eligible to immigrate, and all those unused numbers will then be added and dispersed throughout the other categories to reduce backlogs in the other categories. And huge news, it eliminates the 3 and 10-year bars. So one of the major obstacles to legal immigration right now is that if you have any immigration violations, any whatsoever, you have to go back to your home country in order to process your paperwork. But if you've been here for more than 1 year illegally and you leave the country, it triggers a 10-year bar to reentry. So it the current law creates a situation where you have to leave, but the minute you leave, you can't come back for 10 years. And the result is that no one is willing to do that. So we have a whole group of undocumented people in this country growing simply because of the 3 and 10-year bar. And so this will allow people, even if they can't adjust through one of these provisions, potentially to adjust through a different provision by leaving the country, getting their green card abroad, and coming right back in without being subject to the 10-year bar.
Jeff, here's one question that I've been getting. How quickly is this going to come about? How quickly is this going to affect me? Is this something that, immediately I can benefit from?
Great question. The answer is, well, first of all, this has to pass, right? So we have the greatest chance in my career of getting this comprehensive immigration bill based exclusively on the fact that we control both houses of Congress and we have the president, right? But our margin is so narrow to win this, right? I mean, literally, we need every single Democrat vote and a couple of Republican votes in order to make this happen. And so, if you ask the odds makers of whether this bill is going to pass, the answer is a resounding no in its current form, right? And a resounding I don't know in any other form. Because realize what happens is this is the proposal, but it's going to get reconciled. People are going to add amendments, take stuff out. So it's definitely not going to look like this when it comes out as sausage at the other end. But also, we don't know when or if that's even going to happen. So all we're doing right now is kind of digesting what Biden's plan is, but realize that what that looks like at the end is not going to be anything near what this looks like.
I'll also add that Biden has explicitly said that he's willing to break this up and do it in kind of like piecemeal, not, this big bill that we're looking at right now.
Yeah, and that's interesting, Zach, because the strategy amongst advocates in the past is always like, we want the whole enchilada. We only want CIR or nothing because, if you only do employment-based, you're leaving out family. If you only do family, you're leaving out employment-based. I think the strategy amongst the advocacy community has actually changed. In other words, I think people realize we're never going to get the whole enchilada. We're never going to satisfy every single interest group on immigration. And so I actually think there's a really good chance that these will be split up into different components. I think there's a very solid chance we may actually get some DREAM Act provisions and some agricultural provisions.
So that's what I was going to ask. If you had to guess, if you guys had to guess which broken up pieces might get passed or passed first, what do you think the most likely are?
For me, it's definitely the DREAM Act, TPS, and ag workers. Getting a path to permanent residence, I think that's the harder push. That's going to take a lot more Republicans to get on board with that than the DREAM Act or ag workers or TPS. That's my opinion.
Yeah, I mean, the DREAM Act has been popular in a bipartisan way for so long. Just politics means that it hasn't been passed. So my money's on that as well. I'd also say the reforms on per country limitations for employment-based categories, I think that might be up there. There have been pushes for that in the past, and I could see it happening. Yeah.
One of the questions that came up here is, was there anything in there about limiting the president's 212F power? And I will say that it codifies that you cannot discriminate based on religious grounds any longer. It puts that in as one of the things on which immigration, you can't discriminate in terms of immigration is religion. To me, that is a direct response to the president invoking 212F in the Muslim ban, right? I mean, that's a way of, so I think the answer is yes. I think there is some codification, some restriction around presidential power, at least as it applies to religion. Anything else that you all want to add about from the Biden bill?
Well, there's one thing that will affect that would affect a ton of people, and it's that U visa applicants get employment authorization. Well, not only that, U visa applicants would go, or grants per year would go from 10,000 to 30,000. So currently there's a huge backlog. If there's a new U visa applicant coming in to talk to me, I usually say, it's rough guess, it's going to take 5 to 10 years until you have a U visa. And in the meantime, there is a way to get work authorization, but it requires an adjudication related to the U visa, and it normally takes years as well. This proposal makes more visas available per year for victims of crimes, and it makes employment authorization more readily available while you're waiting. So it would be a big help to people who are applying for both T visas, who are victims of trafficking, and U visas for those victims of crimes. The other thing I think it would do is kind of independently, if it all passed, would be independently kind of clear that backlog, because a lot of people in the U visa line might just take advantage of the lawful intending, I don't have the acronyms down yet, the LPI status, and fix their status that way. So a lot of the line might actually get cleared out by other legalization provisions.
Yeah, that's one of the things that's most exciting to me, is that in order for a real comprehensive package to work together, all these components have to fit together, right? Because if you push in one direction, it can cause problems in the other direction. And what I like about this is that they've thought about everything, right? So the employment-based backlogs, they're thinking about those. They're thinking about the family-based backlogs, but they're also figuring out ways to avoid problems in the future, right? Like the 3 and 10 year bar, I believe nobody knew the unintended consequences of the 3 and 10 year bar and how much it would increase the undocumented population. And so I think there's been a lot of thought put into this bill about how do we prevent the problems that we've created in the past. Zach, if I've ever said I'm a citizen, is that a problem?
For you, no, but for if you're applying for citizenship and you are not a U.S. citizen and have not been a U.S. citizen, then yeah, it's a bar to being a citizen or having admission in general. It's a major issue that's extremely difficult to get around.
Yeah, I've always told people that you might as well be an axe murderer if you've ever declared yourself to be a U.S. citizen. The consequences are the same from an immigration standpoint. This bill changes that. It says that you will not be held accountable in terms of immigration for misrepresentations or false claims to citizenship made before the age of 21. So, that's a big benefit to a lot of people who've been shut out of the system since 1996, because at some point on a job application or an I-9 or whatever, they said they're a citizen.
Do we know whether it creates a waiver for those who may have false claims to citizenship as adults?
It does. I did not see that in the provisions. Really good question, Aaron. But as far as I saw, it's only an exception, not a waiver. Permanent partners. One of the things that has always been an issue is, where do permanent partners, people who are not necessarily married, not necessarily in heterosexual relationships, but they have kids, they have adopted kids, they have biological kids, and they want to immigrate. This bill will add permanent partner to any provision of the law where they talk about an otherwise married couple. And a permanent partner would be defined, a partnership would be defined as a couple over the age of 18 in a committed, intimate relationship where they're financially interdependent and not married, or in a legal permanent partnership, and not a first, second, or third degree relative. So it will basically say that if you meet those qualifications, you can also immigrate to this country, and your permanent partner and your kids under the age of 18 will be able to immigrate with you. Also important, based on numerous lawsuits, is that your nationality of birth will now be determined based on your genetics, not your birth certificate. That's important because for many men who have children that were not legitimated on their birth certificates, they can't derive citizenship or provide benefits to those kids based on the document. So Now they're saying essentially that we're going to make those determinations based on actual genetics, not just based on what some random document says. We have a lot of questions in the chat box about DV and how that's going to be implicated. Most of those questions are about the lawsuit, which is not what we're going to talk about today. But importantly for DV applicants, in the bill, the number of DV recipients every year is increased from 50,000 to 80,000. So, some indication about how this administration views domestic diversity visa applicants and their value to our country. Go ahead.
It's getting kind of widely reported, and it goes back to your point, Jeff, about kind of looking at the problems that we've already been facing. One of the bad provisions in here, I suppose, there's a new provision that allows the Secretary of Homeland Security to consult with the Department of Labor and create these zones where he can kind of limit any sort of employment-based immigration, both in a non-immigrant way and an immigrant way. I think that's in direct relation to the COVID crisis, and we're seeing on how the Department of Homeland Security, the Department of Labor, the President, and everybody's trying to handle immigration in the context of COVID when we have this massive recession and economic crisis. But it's widely open to abuse, and hopefully not something that gets through all the way to the end.
Let me talk a little bit about some of the employment-based provisions. There may be people on the call who are interested in what's going on the employment side. We've talked about the employment-based backlogs. A couple of other provisions that will help in terms of reducing the backlogs. First of all, if you've received a doctoral degree, a PhD or higher in a STEM field, you will no longer be subject to numerical limitations, meaning you can apply for a green card without a quota. We have a lot of people who are in this capacity from India or China that simply can't get green cards because the backlogs are so long, and that will definitely help those. In addition to that, regardless of whether you have a doctoral degree or not, if you've been waiting for 10 years for your employment-based green card, there's no longer a backlog after 10 years. In other words, after 10 years, you're eligible to immigrate, and that provision will take effect 60 days after the implementation of the bill. More importantly, starting in 2022, they will eliminate employment-based country caps. So all employment-based cases will no longer be subject to individual country caps. This will be huge for Vietnam, China, India, other places where there's backlogs in certain categories. Another significant benefit, recognizing the value and the importance of what we call essential workers to our economy. Essential workers meaning jobs that require less than 2 years of experience. Right now, the numerical limitation per year on those is 10,000. It increases it to 40,000, but it also allows an additional 10,000 numbers to local communities. So local communities will be able to reach out and say, I realize that we have this numerical limitation for other workers, but we really need it here in rural agricultural Kansas because of our economy. So they can apply for an additional 10,000 numbers based on local need. One of the things it does is it makes an F1 dual intent. Why is that huge, Zach?
Well, so first off, a dual intent visa means that you're able to come to the U.S. with the intention of, doing what you're doing with your student visa, for example, but also to intend to reside here permanently. A dual intent visa basically allows you to come and study and also have the intention of immigrating permanently. Without that, it is very tricky if you are, for example, coming on a student visa and your parents or somebody has already petitioned for you in the past to get a green card. It can be very difficult for you to demonstrate what's called non-immigrant intent. And successfully get that visa. So this would eliminate that and mean that, even if your parents, your spouse has applied for you to get a green card, you're still able to come here and study.
And it also allows you to extend your F, your L, or your O while you're in permanent resident status. So right now there's a statutory limitation, for example, for L's of 5 years or 7 years. If you're in permanent residence, it will allow you to extend those visas even if you've got permanent residence pending. So another huge provision. Anything else on the bill before we move on to the enforcement priorities and what they're doing with those?
Jeff, did you mention that spouses and children of employment-based, you mentioned that already?
Yeah, and it will allow spouses and children to immigrate. They will not age out. Children will not age out for while an H is pending. H4 spouses and dependents will be able to get work authorization. So, these are provisions that will definitely benefit dependents of employment-based applicants as well.
And I'd say that's especially important now. We recently had 3 years of the regulatory goal of eliminating employment authorization for H4s. So to have that in statute means that no future restrictionist immigration administration could come in and say, well, no, spouses don't get employment authorization anymore. It's in statute, and that makes it a lot harder to get around.
Another thing that I want to throw out there, because we've talked about employment, but another component of this is employer sanctions, employer compliance, right? So one of the things that employers are going to deal with is now all of a sudden there's going to be people coming to them that say, I have a new identity, I have this new card, I'm now legal, and employers are going to be thinking, what do I do with this person, that's now legal? And the bill actually addresses this, and it says that no employer will be held accountable for employment compliance for continuing to employ someone after they've become legal in the country. So really, really important that they want to make sure that people aren't losing their jobs suddenly because they have legal status and employers are wondering what to do with them. So on the employer sanction side, there's also some provisions. All right, any questions in the chat box on the bill before we go on? There is a question here about IR5, retired parents of US citizens. That is not a provision of the bill. I've always thought that was a really good idea to get retired parents into the country, but it's not. There is a provision for you to apply for your parents, but there's not a separate provision for retired individuals to come into the country. All right, Aaron, talk to us about the enforcement priorities. You're on the National ICE Liaison Committee, so you've kind of had an insight into what's going on this. So tell us about the enforcement provisions.
Yeah, so up until now, what we've been talking about is proposed changes to the law and all this great stuff that could happen if Congress can pass a bill and the president signs it into law. And all of this stuff would require Congress to pass a law. But in immigration law, there is the law that's written by Congress, and then there's the kind of gray area in and around the law where the presidential administration that's in power gets to kind of make their policy decisions and decide to what extent they want to emphasize enforcement, deportation, things like that. So under the Trump administration, the policy decision was maximum enforcement. We are going to try to deny every application that could be denied, and we are going to try to deport every person who could be deported. They explicitly said from the beginning that they weren't going to prioritize people, meaning every person who fell out of status or became deportable was a priority in their memo. Now that was a departure from the last years under Obama, and what the memo that was released yesterday from ICE says is they're going to put some priorities back into place. These are interim priorities that came out yesterday, and they are supposed to guide ICE in deciding when to issue a detainer, when to detain a non-citizen, whether to file a notice to appear, that means put somebody into immigration court removal proceedings, whether to stop somebody and interrogate them, whether to release somebody from detention, whether to grant deferred action or parole, and whether to enforce a final order of removal. So the priorities that I'm going to go through are supposed to last until they are superseded, which is supposed to happen within 90 days. So these aren't going to last very long, but they're kind of the placeholder priorities while they do a deeper study, and then Secretary Mayorkas, the Secretary of the Department of Homeland Security should have something more concrete. But in the meantime, these are very important because they're effective immediately. It's not like the other stuff where it has to pass Congress. They're effective right now, and they will make a big difference for a lot of people in removal proceedings or with final orders of removal right now. So let's walk through the categories. There are 3 of them. These are what they call presumed priorities. So the first category is national security. Any non-citizen is presumed to be a priority under this category if they're engaged in or suspected of terrorism or espionage. Done. Category 2, border security. Anybody is presumed to be an enforcement priority if they are caught trying to enter the country unlawfully after November 1st, 2020, or if they weren't physically present in the United States before November 1st, 2020. That last little part is interesting because what it's put in there to say is that people who enter on a visa, a visitor's visa or any kind of visa after November 1st, 2020, and overstay are a priority for enforcement actions, which is not necessarily the way that it was under Obama. That little part is also actually harsher in some ways. But the basic idea behind the border security is that they want to draw a line in the sand on November 1st, 2020, and people who are here before that, if they're not otherwise a priority, they're not going to be a priority. People who came after that are going to be a priority. The third, and the one that's of interest to probably the most people, is the public safety category. What it says is that people are presumed to be a public safety priority if they have been convicted of an aggravated felony as defined in immigration law, and they are found to pose a threat to public safety, or if they're involved in gangs or alleged to be involved in gangs and pose a threat to public safety. So we're not going to get too far into the weeds about the definitions of aggravated felonies or anything like that, but what this means, if it's implemented faithfully, is that people who don't fit in the categories that I just went through are not enforcement priorities. So if you have a case in removal proceedings, you can be approaching the prosecutors in removal proceedings and asking for maybe a motion to terminate. You have a final order of removal. You can be approaching prosecutors and asking maybe for a joint motion to reopen. Why? Because look at your memo. I am not a priority. If you have a final order of removal and you have a petition for review pending at the 10th Circuit, normally it's very hard to get a stay of removal. This memo specifically says that absent compelling circumstances, they should not be deporting people whose removal order is subject to judicial review. So there are a lot of people who should be able to benefit as long as ICE attorneys and their officers faithfully implement this memo. Again, it's only for 90 days, and then it'll be replaced by something else. But for the 90 days, it's not optional that they follow this. The memo says that they shall follow these priorities, so we, for our clients' cases, we're going to go through them all and make requests to either the ICE deportation officers or the ICE attorneys as appropriate for any action that consistent with these priorities that we want them to take, and see how that goes.
One of the questions, or one of the things that we've been able to do in the past, especially in the Obama administration, was administratively close cases, right? Where maybe the person doesn't have a great case for relief from removal, but they're also not an enforcement priority. We were able to just kind of take them off the docket and get work authorization for them. This memo doesn't address administrative closure. Can you explain why that is, Aaron?
Yeah, so that was one of the really the key tool for prosecutorial discretion for cases in removal proceedings under the Obama administration. But two things happened during the Trump administration to kind of take away that tool. One, Attorney General Sessions issued a binding decision that said that that administrative closure could basically no longer be used, that judges didn't have the authority to order it. But that decision actually got overturned in a few circuits, and administrative closure was still happening in some places. So they actually, just this last year, just before really the change of power, they got a regulation finalized, which did away with administrative closure. And so it's really not available for them right now. I believe that case is subject to litigation, or I'm sorry, that regulation is subject to litigation, but has not yet been determined. And so it's just not a tool in their bucket right now. We expect that it might come back in the next year or two, either through new regulations or through an injunction or through some other means. But for right now, it's just not one of the tools in their bucket.
Yeah, I mean, the other thing I would add to that is that this memo is really just Department of Homeland Security. It only applies to the actions of DHS, right? Because Ali Mayorkas has already been, nominated. He's in his position. He can do these things. Merrick Garland, the head of the Department of Justice, has not yet been confirmed. And so we don't have yet the Department of Justice enforcement priorities memo, and they will have one. They'll have their own separate enforcement priorities memo. And a lot of the things we're talking about right now with regard to administrative closure have to do with the power of an immigration judge as opposed to the power of a DHS official. So I'm hopeful that when we get the DOJ enforcement memo, that it will tell judges that you should and you do have the authority to administratively close cases, and that also is an exercise of prosecutorial discretion. So I'm hoping it will be there in a different memo. Same thing with detention decisions and alternatives to detention. I'm hoping that we will see some more action on that in the DOJ memo.
So one other thing that I wanted to add is about that public safety category. One of the triggers for possible priority treatment is a conviction for an aggravated felony. And like I said, we're not going to go into the definition of what that is, but it suffices to say that an aggravated felony for immigration law does not have to be like that serious a crime.
It doesn't have to be a felony, nor does it have to be aggravated.
Right. You were caught with some drugs when you were 20 years old, and they said it was intent to distribute, and all of a sudden you might have an aggravated felony where you never served a day in jail and thought it wasn't that big a deal. But what I wanted to say about that is that it really is a two-step analysis to that. So just because you have an aggravated felony does not mean you should be considered a public safety priority. They also separately have to make a finding that you pose a threat to public safety. And in doing that, the memo instructs them to take into account things like how long ago it was, whether it was a very serious crime, whether there were many crimes, personal and family circumstances, health, medical factors, ties to the community, rehabilitation. So there's plenty of room to argue that, yes, maybe I have an aggravated felony, but I don't pose a threat to public safety, so I'm not a priority. And what's really important about this memo is that it sets up, or it begins to set up accountability mechanisms for the ICE decisions on this. So these decisions eventually are going to have to go to the field office director and potentially above that to ICE personnel in Washington, D.C. to make sure that these priorities are being consistently applied throughout the country. So it's not just, it shouldn't just be I don't think it will be just a case of, oh, my immigration officer doesn't like me and they're going to deny my request. No, this should be able to be elevated, and it's like the equivalent of an appeal for a prosecutorial discretion request.
Zach, first of all, anything to add to that, Zach, to the enforcement priorities?
Nope, nothing to add there. So
any advice, Zach, for people who are hearing out there, I'm hearing from attorneys that we should get in line to file these applications, and there's a process now, and we can file for the DREAM Act. What advice do you have for people who are hearing those things and freaking out that they may be last in line?
First off, none of those things are law yet, so there is no line for you to get into. My advice would be to give us a call. Set up a consultation, but in actuality, don't worry about it until this becomes law. Keep an eye out our page, maybe sign up for our newsletter so you can stay up to date on what's being passed. But very much, no need to worry about it right now until these things are actually law.
Yeah, I think that's a really important point. Whenever things like this happen, right, that could potentially benefit millions of people, the sharks start swirling, right? I mean, it's like people come out of the woodwork to make money. And what I want you all to hear is that don't trust anyone that tells you, that tries to take money for anything on any of these provisions, because they are not law yet. Also, even if they do pass, please don't use a notario, a person who's not authorized to practice law, to help you. In reality, you're better off doing this on your own than using a notario, because we've seen hundreds of cases where people take money, millions of dollars, and then skip town and never file anything. So I would encourage you to really use your best judgment on when and if this happens. Be a good consumer. Make sure that you trust the person that you're working with, and that you have established a good relationship, and you know that they're capable of doing this and that they know what they're doing. So that's why they are PSA.
And that they are actually a lawyer.
Yeah. All right. So let's see if we have any other questions in the chat box. I don't see anything new. So we will wrap it up there unless anyone has anything else.
No, I would just echo what you guys were saying, that there's actually some positive things to look forward to for the first time in a long time. And some of this stuff isn't quite ready yet. It hasn't passed, but it sure feels good to have positive changes to talk about, rather than just the latest disaster, as it had been for a number of years there. So yeah, keep following the news. Be good consumers. Don't hand your money over to somebody who says they're saving you a place in the line. The line doesn't exist. And yeah, let's hope some of these good provisions pass.
Yeah, thank you. And follow us on Twitter if you don't already. We try to keep really current as things are announced. We try to put it out on Twitter as much as possible. So follow us there. Also follow us on Facebook, because we will continue to have Facebook live sessions and Q&As as things develop over the next few weeks. So thank you all for participating. Thank you for joining us, and we will see you next time.
Thanks all.